Conflicts of interest can arise in M&A transactions when members of the company's board of directors or management have personal interests that differ from the interests of the shareholders they're supposed to represent. These conflicts can lead to decisions that aren't in the best interests of the shareholders. Before we look at some specific types of conflicted transactions, let's start our discussion by considering the judicial standard of review applicable to conflicted transactions. If a conflict of interest is present, the standard of review is elevated from the standard business judgment rule to the more discerning entire fairness standard, established in the landmark case Weinberger v. UOP. Under this standard, the board must demonstrate that the transaction was fair to the shareholders in terms of both process and price. Fair process, also called fair dealing, examines how the transaction was timed, initiated, structured, negotiated, and disclosed. Fair price, on the other hand, considers the economic and financial aspects of the deal to ensure that the shareholders received fair value. The application of the entire fairness standard can be avoided, however, if the transaction is cleansed or ratified pursuant to Corwin v. KKR Financial Holdings, LLC. Under Corwin, the business judgment rule will apply if a conflicted transaction is ratified by a majority of fully informed, disinterested, and uncoerced shareholders.